Hello. Hello. Um, Glad to see you all here. We're going to go ahead and get started since we said 6 o'clock, and we want to stay true to what we tell you guys. So that's what we're going to do. My name is Pam Schmidt, and I'm just going to be the person with the microphone tonight. And Bill Peace is going to give us a presentation. But before we do that, I just want to go over a few things. First thing I want to ask you all to do, if you haven't already done it, is please silence your cell phones. Just a few things to remind you all. Please hold your whispering or conversations, private conversations. We'll have Q&A, but we want to give everyone an opportunity to hear what's happening and not get distracted by other conversations in the room. You heard, already said that. When he's concluded with the presentation, then we'll take Q&A. So we'll have a line just like we've done in the past. I'll have the microphone, and we'll handle it that way. We're not going to totally say you only get one or two questions, but we do want to give everybody the opportunity to be heard. So be ready with your question, and if it leads to another question, okay, but if it gets too long, I may say, okay, let's let somebody else speak. The last thing is, hopefully, we're starting at 6. This will last an hour. Not very many people here, so maybe an hour will be long enough. And then, of course, if we leave here, and I'll remind you of this, but if we leave here and you still have another question, send it to ontheranch@hollylakeinfo.com, and we'll repeat that again later, and then we'll get back with you with a response. So we're going to start with Mr. Bill Peace.
We good? All right, perfect. Thank you, guys. So I started the town hall that we had the other day with a question on how many people haven't attended a town hall on the common areas. Is anybody in here that hasn't? Okay, so we got a few. Okay, so we elected when we put this together to go back and talk about what some of the benefits are of the acquisition of the common areas, and talk about the contract a little bit, and hopefully answer some questions if you guys are new to this. There is a video of the Saturday session. There'll be some questions out there that maybe will help you understand a little bit better if you guys want to go back and watch that. It's posted out on YouTube. Okay. All right, so as you guys know, we did a vote, and we're now going to do a revote, and there's a reason we're going to do that, and I'm going to go through what the reasons are for that. The common area benefits, I'm going to cover that. I'm going to talk a little bit about the contract, and then, where do we go from here? How do we get from here to the end? I was thinking this is like part 14 of the 14-part town hall sessions that we've got. Hopefully this will be the last town hall that we do, but we do want to make sure that if there are any questions remaining, as Pam said, let's get the questions answered, because it is very important that everybody, ring in on this vote. Okay? All right. So that's that. So why are we revoting? So originally we put in an attachment to the letter of intent that was done with Silverleaf back when we did this before. And the letter of intent, the purpose of that was to lay out the terms by which we would acquire the common areas. And in that was an attachment that included a description of what the property was that went with that. And essentially that property is, everything in the box except your parcels that you own. Okay, and that's what's kind of the definition, high-level definition of the common areas. Unfortunately, there was 9.2 acres that was also included in the property that Eric Ho acquired with the resort. It's adjacent to that. I'll show you what that was. And so since it was in both, he closed. That 9 acres needs to come out of our attachment A, and so we've done that. Okay, the other thing we've done is we've moved from a letter of intent to a contract. And the good news there is you can see the actual terms. There were questions last time about, well, what if something changed between LOI and contract? And so now you can see the actual contract, and as I'll go through, it is in fact signed. We considered this change of 9 acres a material change, and so with that, we're going to revote. Okay? All right. Common area benefits. Really, some of this might seem obvious, but this is all about controlling what Most people, including myself, thought or a lot of people, maybe when they bought the property, they thought we owned it. You know, I thought we owned the lakes and golf course and all those kind of things, and come to my surprise, we didn't. And Adam took me through, some time ago now, kind of that history from 1971, how this thing got very convoluted along the way. And I think this acquisition represents a huge opportunity to put a whole bunch of that back together. This ranch was whole, it was parsed up, you know, there was a wilderness area, that's a question, and then we got the common areas and whatnot held by Silverleaf. So this is an opportunity for us to put this thing back together, which is why we worked for, 14 months or so on this project to try to get this done. It's about control. We, in the contract, agreed that we would put together an amenity use agreement. You know, with the timeshare over there, we shared amenities, right? So we used that pool, they used our amenities, and at a very high level, there was some dollars exchanged for them to participate in those amenities, and that didn't work very well for us. So what we agreed to do was we agreed to take the common areas, if we do this, and write an amenity use agreement with the now owner of that resort over there, so that he'd be able to use these amenities. But the problem is right now, in terms of that agreement, is we don't know what he's going to do with it. And so until we do, we can't write that agreement. So it's a big step beyond this. But the reason it's important to own it is right now he's had conversations with Silverleaf, he's had conversation with us, we've had conversation with Silverleaf. 3 parties to that's not going to go anywhere good. And so once we own it, we'll be able to sit down with Erico once he gets his plan together and decides exactly what that's going to look like, and then we can write it. For instance, what we might do for access with condos might look a little bit like what's over here. If he mows down some buildings and puts in houses, it might look very different. If he did some rentals or VRBOs, or if he did, we don't know what he's going to do. So we can't write one agreement that applies to all of that. And so we've talked about multiple options. It's going to depend on what he does, and it's probably, at least our early thinking is, it's going to be something fairly short term, because I think his plan will unfold, and what the right thing to do for the membership here will also unfold with that. So that was the thinking, and that's kind of where we are on that. The other thing, and this one's pretty important, the state does offer some grants for things like, you know, dam repairs, water treatments, things like that, but you got to own the land. So that's one of the benefits is, as you guys know, we do treat the water on a pretty regular basis, and were we to have some issues with the dam, there's conversations that go on with TECQ, and so we need that ownership to be able to have those conversations. And if there's monies available from the state, go after that. Okay? And then, you know, everybody looks at their taxes and decides whether to protest or not. A lot of people do. We pay the taxes on all of this common area, but what we don't have is ownership, so it's difficult to negotiate and say, you know, it's not really described well, it doesn't really represent what you've said it was, it's not worth that value. And so the protest capability comes with ownership. Okay? So those are just some of the high-level benefits. Okay, so on the common area, again, this is really high level. I know you can't see this. The point of this slide is that when we were doing the LOI and we were identifying this, we've got a big map that shows all of what's included in this. Nothing changed but the 9 acres, and that's represented by that circle there. I'm going to show you what that looks like, but that's where in the common areas exist. All the other things are there. And again, this is not a detailed picture of every square that is the common areas, because remember, the common areas are everything that is not owned by a homeowner. Okay, so these are the 2 parcels. They are adjacent to Erico's property. You can see just northwest of where he is, this on the southwest side of Greenbrier Dam. And that's where the parcels are that went with the resort. So that will not be part of what was originally in Exhibit A. Okay, so on the contract, again, I mentioned it would transfer the common areas to us. You know, the consideration for this is $10. Effectively, it's a transfer to us. We will be responsible for closing costs, you know, legal fees. If we desire any surveys, that kind of thing, we'll pay for those. But that's what we're responsible for. We have had legal fees going through the LOI process to drive that and do the negotiations, and then we've now had some in prep for title and for the negotiation of the contract. Okay? As I mentioned, we will negotiate an amenity use agreement with Airco. It is in the contract. And again, it is not specific other than that we will negotiate that in good faith, and the charges for that use would be similar to what we charge for similar things. You know, if it's I mentioned the condos over there as an example. Okay, but the idea is that if he does similar to something what we do, then they'll pay what we pay. And then I think there was a question in the last town hall, what would happen with that over time. One of the things that didn't happen with the Holiday Inn over time is, you know, it was $1 a week, and it stayed $1 a week for, 30 years, right? And this would be expected to go up. That's why we got to get that contract right. We got to get that contract right. Exhibit A lays out the details. I encourage you to look at it. And this is something that we asked Silverleaf, this last one, to do because we wanted you guys to be able to see the contract. Not just see the contract, but see the contract they signed. So they have signed it. So if the membership says, let's do this, then the board will sign it. Okay? All right, next steps. So we did the 2 town halls, trying to get all the questions to everybody. We do have Own the Ranch as an email. We did the vote notification on the 28th. We sent out the ballots on the 3rd. Some of you may have already received them. I noticed that some people talking about getting them. It will close on the 25th, get them back, and then they will be counted on the 26th, and we will announce to the membership the status of that. If it is approved, the board will sign it, sign the contract, and we will move to closing. A lot of prep has already been done with the title company to make sure that they understand what we're doing, what the contract looks like, what the exhibit looks like, what the land descriptions, all those things, so that we can get the deeds right and the title insurance correctly and all the fees set up. So we anticipate that would happen sometime in August. Okay? So that's that. We're going to move to questions. We did have 2 questions last time, and Adam, hopefully you saw her note. Maybe I'll answer one of those. Yeah, as soon as you know what it is. Yeah. Okay. So one question was, I mentioned this amenity use agreement, and so Airco, when he bought that, when his company bought the resort, they have the right to negotiate with us on an amenity use agreement, but not the obligation. So they could opt out. So the question came up that said, well, are we going to put up some additional gates to try to control traffic? Might we put one over here, one over here? He does have an easement, so we will, through the common areas, we will own the road where the sign is. Let's back up, right? That road coming off of 2869 all the way to the Greenbrier Dam down there at Golf Drive. So that road we will own as part of the common areas, but he has an easement to it because he can't be cut off to his property. So he will be able to go up and down that road, okay? So the question is, well, what if he opts out of the amenities? What if he says, I don't want to do that. We're not going to, do that with any of the people that move in over there. He could certainly do that, and in that case, we might do something very different with gate access so that he has access to his property, maybe not everything else. If he opts to, Build a wall. That was said in the last meeting. Okay? So until we know, we don't know, right? But are we looking at options? And we are. We're looking at options for both scenarios. What if he's in? What if he's out? One of the questions is, well, what if 3 owners over there want in and, 126 want out, right? Well, that's going to be very difficult to manage, very hard to figure out who can come through the gate, who can do what. And so what our position at this point is it's kind of all or nothing, right? So, if he does, condos over there and he has 130 units and he puts them all in an association, then maybe that association pays us for access and they recoup it from those folks. I don't know. It depends on what happens. But it can't be a one-off, for everybody. And they get something, I just want to play pickleball, I just want to swim in the lake or whatever. So it's pretty complicated to figure out what that agreement needs to look like because there's so much we don't know right now. So a lot of people have had a lot of questions. We got a lot of questions in the last one. What are we going to do? And we just don't have anything definitive until we know what he's going to do. And so we'll work through that. But it's a huge piece of work that needs to get done to protect everybody's property here. Okay. So that was one. There was, Adam, the question on the implication. In the contract, there's a reference to we would become the developer for the property. And so, you want to take that?
Yes. Good evening, everyone. Goodness. Wow. So legal implications of becoming the developer. Really, as we had talked probably several months ago at this point, I guess it's been longer. It doesn't feel like 14 months, but it's been a while. It's
But it
really,
has.
but it has, yes. It's really just closing the, well, that sounds horrible. I'll stand over here. There we go. It's really just the closing of kind of that loop. So if we refer back, and 9 times out of 10, when you see any reference to developer, it's going to be in those restrictive covenants, those deed restrictions that were authored anywhere from 1972 to 1976, and then we've got a couple of amendments past that point. But as it relates to the developer status in there, typically what you would see in a homeowners association or a POA across the state of Texas would be at 50% or 75%. That developer status would then be transitioned over to the association. And that's simply not the case that has happened to date. So this kind of wraps that up and makes you essentially the developer, the association, the developer, because there are certain rights that go along with that. So legal implications, there's not a ton, but really what it does is it gives us assurance and it wraps it up and puts a bow on it so that moving forward, the association is the only one, that control your common areas. So I hope that answers the question.
Yep. We certainly don't want a situation where we got to go ask Silverleaf if we can do something.
No.
So, thanks. Okay. Pam?
Okay, so just a couple of things that I did not mention before, and that is the people sitting here are members of the Silverleaf Committee who've been meeting with Adam to make a recommendation to the board. So we're here, all of us can answer questions that you may have. Dwayne Dunk, Bill already did his part, Jim Dixon, Michelle Tolucci, and Rick Reynolds. And then also up front here, we have members of the HOA board who are here. Bill Wilkins, Warren Blash, Stacy Fink, and Mark Allen are here. Did I miss somebody in the audience? Okay. So with that, I think we're ready to start answering your questions. Who wants to be first? Do you have any questions?
Just
Come on
Dennis.
up.
You're going to hold it.
Yes, sir.
I'm Dennis Dossie, Section 4.
Thank you.
In the contract, there's and you may have addressed this and I may not have understood yet, but there's a declaration of access easement. Does that relate to what you were talking about with the roads and how he can get to the dam and the so forth?
Yeah, I'm not sure exactly what part you're talking about, but yes, there is definitely,
Well, it's a couple of pages.
is that the Exhibit E? Okay, so that is the easement that comes in through the front gate all the way down to Golf Drive, roughly.
So, I understand there's a lot to be negotiated, and I understand that at this point, it's not a problem. But further along, as they negotiate or don't negotiate for use of the amenities, will we be providing their security and their whatever to get through that gate? And they've got to come through our guys, and we provide the guys, or has that been addressed anywhere in this thing?
No, and is, I guess, the quick answer, that we cannot keep them from getting to their property, which means they do get to come through security unless we didn't have security there. So they go ahead.
Don't they have the other road over there, though?
They-
I'm
they-
not concerned
They do.
about how they get in, but that it looks as though we're gonna be providing the guy at the window that checks their people, and if they end up with 130 units and so forth, you know, that's a lot of people. So I was just
Yeah.
interested if that's ever been part of the
It's been part of the discussion. The easement's been in place since, there's some documents out there. One of them was in 2001. It was extended. There was one prior to that where that easement was created when the additional Holiday Inn amenities were created. As you may remember, the 1990 court case and all that kind of stuff. So they built the tennis court and they built some other stuff. And so they extended the easement through there. And so the resort has that easement. And so when it got sold, it still has that easement. And so is it difficult? Yeah, because it runs right through security. It's not clear what we're going to do yet.
Okay.
But we've had a lot of conversations about it, but we don't have a solution yet.
We can't restrict them.
We
from
can't
using
restrict
that.
them getting in and out of their property.
That's correct. Another question, come on up. And also, yes, as Dennis did, please give us your name and section number.
Ben Zecchi, Section 4. Thank you, everybody. Appreciate the opportunity to listen in. As it relates to negotiating with Eric, are we going, as a membership, have any involvement in review of that negotiation, or are you going to do that independently of us as an association?
I don't know that I have an answer to that. I know that we've spent a lot of time, and I'll take other opinions here. We've spent a lot of time on what that agreement might look like and the implications to the ranch on it. I don't know whether that's something that would or wouldn't be voted on, or from a board standpoint. I don't know.
I don't think from a board standpoint, and if we reflect on the bylaws, there's some stipulations within the bylaws. I think there's 4 or 5 that require, they mandate, you shall take this before the membership. And I don't believe this would be in there. It's fundamental changes to the boundaries of the ranch. It's changes in access easement agreements. It's, can't remember the rest of them.
Diluting the
Say
vote.
again? Capital expenditures, fundamental dilution of the vote.
Dilute,
And new amenities, thank you.
Right.
So I don't know that this would require, sorry, there you are. Don't know that this would require a vote, but I would suspect that this would follow a very similar pattern to what it has been in the past. And it would be, the committee and I would meet, we would risk analysis, we would determine all these different things, and then we would present a variety of different options to the board for their consideration and decision.
Good question.
Arthur Johnson, Section 4. How did that 8 or 9 acres get away on us, and he got those 8 or 9 acres?
Well,
Yeah,
yeah, go ahead.
you go ahead.
Was that it? Yeah, so my understanding was it was included in their survey, which we didn't get. It wasn't a survey for us. And then they acquired it. And that's how it got in there. And then we went to Silverleaf, and Silverleaf said, yep, you're right, we screwed up. We put it in both. I mean, that's how it got in there.
How come you guys didn't catch it? We weren't reviewing that transaction.
Right. Yeah, go ahead.
So I was just as disappointed as you were, to be completely honest. So the signed survey that they did, there were 3 parcels. The signed survey that they did, we didn't receive a copy of that until 3 days prior to closing. When we saw it, I called down and talked to the folks down in Silverleaf, both their legal representation and their ops representation. We had a Zoom meeting, and I essentially said, you're wrong. And they said, no, we're not. Please look at it. And they said, you know what, you're right. That should not have been included, but it is. And almost verbatim, the conversation was, I understand, Adam, but we're giving you a bunch of land, and I'm not going to jeopardize the integrity of this deal to delay it and take out that 9.2 acres.
Why didn't you take them to court?
They're giving us $8.1 million in a non-binding LOI, and all the these other considerations. Do we sacrifice the entirety of the ranch and the common area for 9.2 acres? In my opinion, would be no.
The other thing is, I don't know that we would have had standing to take them to court,
Yeah.
because it's not ours to tell them they couldn't sell it. It was their property. Was it done in error? Yes. But that didn't mean that we could sue them because they told us, hey, we want to give this to you, but now we're not, we got it included in here. So I don't know that, haven't talked to an attorney, but I don't know that we would have had standing to sue them, even if we could have, because it was so immediate. The closing was immediately after we found it. Dwayne, did you want to add something to that?
Yeah, Pam, to add to what you said, you're exactly right. Where it was committed to us was in the LOI, which specifically is not legally binding, which would undermine our legal standing. If we did try to enforce it, it's not enforceable.
Did you have another
Well, you didn't
question?
try.
Okay, so do you have another question, or, okay, what's your question?
I can stay here all day.
No, you're not going to stay here all day and be argumentative. We'll be glad to take your questions and answer you.
Censor me?
Yes, I will.